Hi folks, you're with Tacitus today at your Pushback Challenge. Thank you for joining this audio live stream. In this essay, I'd like to talk about the way the globalist stooges and flunkies that are all across the Biden administration now, the way they present cases and the way they behave and talk in the Supreme Court of the United States. Now, I'll draw a parallel with this behaviour as I believe exists anyway, in my opinion, with the behaviour that you see in, for example, the Twitter hearings or the confirmation hearings for various government positions as the Senate reviews the credentials of various candidates. Now, I'm the standard of candidate that the Biden administration, in my view, that the Biden administration is putting forward is a much lower standard than we used to on one side, but also they're radical activists on the other that are pursuing an anti-American, anti-white, anti-male, but very pro-globalization agenda. And their attitude, if you look at the way these people, whether it be the Twitter, social media hearings or the confirmation hearings for government positions, the way they talk to and relate to the Democrat questioners and to the Republican questioners or anyone that's not totally on board with the globalist project. These people are given a lot of tuition in advance on how to answer questions, how to evade answers. They're also told the softball questions they'll get from the Democrat candidates or the Democrat congressmen and so on. So they and if you'll notice that when the question comes to, for example, one of the former Twitter execs being grilled, the question comes from the Democrat senator or congressman, and would you say that the people posting conservative messages are all neo-Nazi, fascist, Hitlers? Yes, that's right. We warned them 100 times, and we did this, we did that, we did it, and we checked on that, and we used external. They're forthright, and their answers are prepared, and they're right in there, vigorously defending their position. But when, in effect, the same question is asked, maybe with a slightly different contextual application, there are, to the best of my recollection, I don't know, I'm not really sure, can't remember, to the best of my, but more importantly is they treat the Republican question with a sort of contempt that is very much tied to, you're not legitimate. Nothing you say or do is legitimate. The worldview you hold is not legitimate. You are delegitimized in my eyes. The Democrat congressman is legitimate, and so I will answer their question, but not yours. You're just illegitimate. You fucking Nazi. And this is the attitude that you see that's permeated throughout the public service and all our institutions. The straight white males and the white history, the culture of the Western world, it's not legitimate. Now this is because the globalists cannot win the legitimacy war. They are just simply not legitimate. They cannot win it. So the only other thing they can do is to delegitimize everyone and everything else that's getting in their way, disagrees with them, questions them, and so on. So it's not a case of winning people over or appearing legitimate. It's delegitimizing everything else. And we see this with the rewriting of history books and, the children's authors. Roald Dahl was, a recent example of rewriting the James Bond novels and so on. Now, is there any move to rewrite the books about hating white people or nothing? So it's only a one-way rewriting, only one way, which is, again, to delegitimize everything, every position, every view, other than the globalist position. Now, I just want to look at the Supreme Court and drawing a parallel between the Senate hearings and investigations and the attitudes and behaviours there, and the same sort of overall architecture of attitude, if I can use that term, that I see in Supreme Court. Now, I should add that I've had to prepare many legal briefs. I've had to prosecute them in court and also be a witness. And I'm hardly a legal expert and don't put myself forward as such, but I do have a reasonable understanding of it, and again have been in court many times. Now, preparing briefs is, in my view at least, an important business. You're going to rely on this brief as to really be the sort of overall roadmap of how you're going to present and argue your case. And it's also where you really have within the brief the evidence you will rely on to persuade the judge, the jury, or in this case in the Supreme Court, the 9 justices, that your argument is valid under law and puts forward the underwriting, if you like, supporting positions that would lead. This could include, for example, precedent or other evidence that you put forward. Now, when you make an assertion, you have to have the evidence in court. That's how the due legal process works. You can't just assert something, and or hitherto that was the case. At least you can't just assert something and say, "Oh, I haven't got the evidence," but hey, who cares? Everybody knows it. So now you see this sort of ideological law, which has really captured the entire Western system of jurisprudence. You see this ideological law. Well, we all know that straight white males are Nazis, so I don't have to prove it because we already know. We do. And so they're able to assert ideological positions and assert it as fact, and have judges, and this could be divorce courts and all sorts of things, have judges. We all know men are violent oppressors of women. We don't have to prove that this instance or that instance or that it happened. We just know it to be so. So this has the effect of ideological law, or application of ideological law has the effect of the assertions, ideological assertions, have replaced the facts and the evidence. Now, it's still a bit different in criminal courts, but I'm not sure about a whole lot different anymore, because the ideological law is creeping in now to every aspect of the law. And so we see this in the Supreme Court. Now, I was looking at listening to a recent case in the United States Supreme Court, where, and again, the Democrats, or the globalist controlled Democrats and their flunkies and goons and ghouls and so on, the Supreme Court is now not legitimate, as they would assert anyway. It's not legitimate because it doesn't have 9 Ruth Bader Ginsburgs in it, or 9 leftist activists. Now, if they had leftist activists in there, then the court would be legitimate, or ideologically legitimate anyway. And so it's merely because, and even Biden and his goons in the White House have said this, that the Supreme Court's not really legitimate because Trump appointed constitutional judges rather than activist judges, and therefore, because the constitutional judges are a slight majority, sort of a 5-4 majority, because of that, then the court is not legitimate. And if Trump hadn't been there, then we would have appointed activist judges, like a bunch of Ketanji Brown Jacksons, and therefore we would win every globalist sort of relevant case that was important to the globalists. We'd win every case. We wouldn't have to argue it. And this, so the idea of having to argue the case and present hard evidence, that sort of thing, that is factual and based in facts and supported by evidence, the need to do that is in itself an act of evil, white, fascist, Nazi oppression, and so on. So all very ideological. So I looked at or listened to this is from not long ago, less than a year ago, an argument being put forward by one of the Biden administration lawyers or advocates, and I listened to the way she talks, and she sounds like a snot-nosed first-year law student. She's got that tone, that hectoring, ideological, feminist, radical feminist tone, and so I thought, gee, I wouldn't be talking to judges, that way. I mean, wow. But the tone was the same as you see in the Senate hearings and so on. The tone was, well, no, I shouldn't say university. If she was talking to one of the leftist, Sotomayor or one of the leftist judges, then the tone was fairly relaxed and respectful along the lines of, I know in advance you will agree with this. Before I even put up my argument, I know where you will vote on this. And so it's very relaxed and almost a casual tone, and not the tone of a lawyer arguing a case and presenting evidence to persuade, but rather more, we're all friends here, you and me. We don't really need to talk about this. We know what the decision should be. So, it's only those damn fascist Nazis that think the Constitution is relevant that I have to talk. So very casual, relaxed. We're all friends. We're all on the same side. With the Sotomayor judge, or I use Sereni as an example, and that's of course my opinion of their exchange. But the exchange between Sotomayor and the globalist Biden flunky lawyer, and then the difference in tone, say in talking to one of the Clarence Thomas or Justice Gorsuch or Kavanaugh, those guys, the constitutional ones. And because the type of questioning that the leftist judges have is very much in line with the ideology of, well, we all know that slavery and oppression, and we all know that, and so that there was that they accepted the assertion as being tantamount to proven fact, rather than is it a fact in this case, and can you prove it in this case? And that's the difference in the constitutional judges look, is it consistent with the law and the Constitution in this case as you argue it? Not that there's some sort of vague, miasma of outside ideology that we can all just agree on. Now, ideological fellow travelers just go, yeah, we all know this, when in fact that's nonsense. The ideological assertions is itself an invention, hardly evidence. So that when they talk to this lawyer, talks to, for example, Justice Gorsuch, and Justice Gorsuch is quite soft-spoken, very polite, and I thought very patient and indulgent there. The tone of contempt and why am I even bothering to talk to you? You're not even legitimate, you damn fucking Nazi. I'm only doing this because I have to, if we were in control, you people wouldn't have any place in our world. And it was that sort of overall attitude, certainly as I understood it at least. And that's pretty scary when you're actually looking at one of the nation's most senior lawyers in terms of having a position in the government, is able to talk with such impatient, sounding like a schoolgirl, such impatient contempt of a justice of the Supreme Court of the United States. Now, whether or not, I've sort of looked at judges where I wouldn't, they're ideological fanatics, and evidence means nothing to them. And I wouldn't, if they burst out on fire in front of me, I wouldn't piss on them to put the fire out. But the point is, in their position as a judge in a court, then I show respect to that position. I might not think much of them, being ideological fanatics. I may not think much of the process that allows an ideological fanatic to gain a position as a judge. But the position of judge must be, in my view, respected. So I'm a little bit different there. Now, part of that respect is preparing good quality documentation with evidence. So I looked at the online. You can see some of it online. And you can hear them talking about some of it, or one of the people in the court quoting from the documents. And what's quite clear is that these lawyers are putting up an ideological argument, as we all know from slavery and how black people are oppressed and Jim Crow. what we have to do today in 2023 is compensation, and so the whole document, as far as I can see, and again they've managed to get to the Supreme Court with this, which is in itself is I mean, if I was the judge, I'd throw it out. So look, your paperwork is so fucking piss weak. I'm not listening to this ideological bullshit. If you want to come into this court, you will produce evidence supported by facts, and when you're ready to do that and can do it, then come back. And if you can't do it, you've got no fucking case. So you go off and do that. But this is something that is really the work of some ideological, critical race theory hack goon that's put together some high school kid in a hurry too. It doesn't look like they spent a whole lot of time, and has thrown together this ideological bit of bullshit, and then is going to the Supreme Court with it, and then gets impatient with the judges for questioning its legality and its standing under constitutional law. And that's the bit that gets me. You fucking snot-nosed little shit. So anyway, I was looking at this law again. Sounded like a schoolgirl. So it must be someone sort of fresh out of law school. So I went to, I did some digging around on this lawyer and found that she's in her late 40s, and sounds like she's like 21 or 22, and with a snotty schoolgirl attitude. And look, this is the classic poster child creation of the globalist era that we live in. So I mean, she's a lesbian, so hardly a surprise there. Somehow she seems like a very ordinary student at high school, but it seems like she was picked out at around this time. Somehow some globalist talent spotter, maybe the World Economic, one of Klaus Schwab's sort of subterranean goons, noticed her or something. I don't know, but somehow she's been earmarked at an early age. So I suspect in senior high school or possibly early university. So she gets to go to university in somewhere in the middle of nowhere. Somewhere in the Midwest Farm Belt or something like that. She gets to go to university studying some soft course like, English literature or something like that. And in fact, I think that was what she studied. And then this is where things suddenly started to politically at least move for her. So she's given she's made the president of the student council. That is a classic giveaway for there being earmarked for a future political, classic giveaway. Somehow this nobody from nowhere ends up getting the vote. It's almost a unanimous vote voting her as president of the school council or something, so the university student council. Then she's made editor of the university magazine, which is very political and activist. Again, another dead giveaway, poster child being created here. And then she comes, not even having a law degree, she's again just studying literature, goes back later to get some bullshit arts law degree, some third tier bullshit. But then she gets given a clerkship with one of the most activist judges of the day. And so again, another classic, we're preparing you for things in the future, whether or not they're open with her or she just goes along for the ride, because she's not a high IQ person, far from it. Not a moron either. I mean, listening to her argument, she is able to, but she keeps trying to steer the judge. This is in the Supreme Court. She keeps trying to steer the judges back. Don't worry about facts. Don't worry about the Constitution. Don't worry about the law. Just get the vibe of the ideology. So instead of answering questions, she tries to drag the conversation back to an ideological thing, and almost takes a hectoring, finger-wagging tone on the judges, like Justice Gorsuch or Kavanaugh and Thomas and so on. Almost takes a finger-wagging tone with them that they're students in a law class or something, and she's giving them a lesson on how the law should work, which is chutzpah that's way over the top here. Gives away that she's just a fucking activist, not a lawyer. So she then clerks for a couple of the most activist judges in the history of the United States, or modern history at the very least. And so clearly being earmarked for things, then goes into a Democrat Party machine, a law firm, just straight away given a partnership role there. Again, another dead giveaway. This is someone who's got no credentials. So clearly it's a political appointment as part of the overall political machinery and control of the political legal machinery in the United States, and then gets given a very senior lawyer role in the Biden administration. Now, purely on the basis of legal credentials, you wouldn't. You'd give her maybe a job as a law clerk out in the sticks somewhere, but in terms of her understanding of the law and her application of the law, she thinks it's irrelevant, and you can tell by the way she argues the case. Look, the law is irrelevant. Understanding the law, it's been made by white fascist Nazis, so that makes it irrelevant. It's not even legitimate. Why the fuck should I have to argue the laws of fucking Nazis? We're talking about the activism of the modern day, and so she approaches the whole thing from the idea of, well, I don't have to argue the law. Why should I? It's not legitimate. It's made by white people. So the ideology of critical race theory and radical lesbian feminism, those are the issues, and that's how legal decisions should be made, on the basis of that miasma of ideology. Now again, if that came in front of me and I was a judge, I'd throw it out, and I'd recommend to the lawyer registration board that this person be struck off, because they don't know anything about the fucking law and don't care about it, and don't even bother to put paperwork together that supports it. So as far as I can tell, her entire argument was ideological. There were some precedents mentioned, but the use of these precedents was drawing a very long bow. I don't think they applied. If they applied at all to the case she was arguing, that it was a very indirect application. So I think the whole case was a nothing. I think the case that she put up, the quality of it, the evidence, the supporting evidence, and just the pure sloppiness of it. Again, a first-year law student could have done just as good. Then I thought that was something that should never have made it to the court, and certainly shouldn't have been given the very indulgent and patient sort of consideration that, as far as I can tell, the judges were giving it, or certainly the constitutional judges. I think the activist judges would have just waved it through. They could open up the case. Do you hate Donald Trump? Yes. Okay, but case approved. Off you go. It's almost that silly, and the type of questions that, in my view, that the Sotomayers, who in were I to be, wouldn't even make a law clerk, and Ketanji Brown Jackson, the same thing. In my view, is at best a law clerk. Then they will accept this ideological stuff, which shows you how we're on the precipice of a slope that's getting more slippery by the day. That any legal case that may have any effect or precedent effect or anything at all is being judged now on its benefit to the globalization project. If it's not beneficial or harmful to the globalist project, it will not be allowed. A decision will not be allowed. It will only be a decision only in favour of, or in helping or supporting of, or creating useful precedent for the globalist international project. Only those decisions will be allowed. And again, I think we're right on the absolute tipping point of that we're about to go on the other side of the hill, certainly over the next few years, where there will be not a single legal decision made all across the Western world that will not be reviewed by the globalist activists and looked at, and decisions made purely on the basis of its usefulness or not to the globalist project. You've been with Tacitus today at your Pushback channel, and thank you for listening.
So some fucktard down in Canberra,